All right, so if you're thinking that I shouldn't have thrown those subpoenas in the garbage, you busted me. I did. I put them in the patient chart. But those were subpoenas from a law office, from a lawyer. And based on the information I gave you, Jaffrey versus Redmond, you don't have to respond to subpoenas. So I gave him a courtesy phone call after the third subpoena, but I said I'm straight about that. But in this lesson, this section of the course, what do you do when you get a court order signed by a judge? What do you do then? So that's what we're going to talk about here. But either way, if you get a subpoena from a court, could be signed by the court clerk, or you get a subpoena from a court, and definitely with a court order signed by a judge, you're going to want to bump that upstairs because it's your ethical and professional responsibility to seek out and utilize clinical supervision throughout your career as a counselor. But this is not a clinical issue. So it's going to go clinical supervisor, program director, the legal department. So most programs, or all programs, should have a consulting attorney, legal office with a retainer contract, but you're going to want to consult with the program's attorney on that to make sure that the proper steps are followed. But you know what a subpoena means, and we're going to cover more about that. But now we're going to be talking about a court order, which is a whole different ballgame. Okay? All right. So, with regards to a court order, I'm just going to read from here because, again, we're out of the clinical realm and we're into the legal realm. And like I hear so many people say on TV, I'm not a lawyer, and I'm not. I'm a clinician. So, I got to read something. Okay, so, state and federal courts may issue court orders authorizing programs to release information that otherwise would be unlawful based on HIPAA confidentiality. However, certain procedures are required when such court orders are issued. For example, firstly, a program and a patient whose records are sought must be given notice that an application for a court order has been made. The program and the individual must have the opportunity to make an oral or written statement to the court about the application. So, if a court order application has been made, the program and the individual, the patient, we would inform them that a court order application has been made and that we want to respond either orally or in writing. Now, before a court order can be issued, if the application has been made, but before a court order can be issued, there must be a, quote, finding of cause for the disclosure. So this is a legal term, finding of cause. So if the public interest and need for disclosure outweigh possible adverse effects to the individual of the counselor-client relationship and the program services, the order is issued. So information that is essential for the purpose of the court orders is all that is to be released. So the court order has to be specific as to the information that they're seeking to be released, and then you release that specific information. You can't ask for the whole chart or all your session notes. So it's going to be specific, and only person who needs the information will receive it. So only the person who needs that information can review it or can receive it. Again, it probably can't be an open court or it's spoken out loud and given all that patient information. Okay, so a court order may require disclosure of confidential communication if one of the following conditions exists. So I'm going to give you 3 conditions here. Again, I'm not a lawyer, just I'm reading this stuff. One of these 3 conditions has to exist in order for a court order to be issued. 1. Disclosure is necessary to protect against the threat of life or of serious bodily harm. Okay? And 2, disclosure is required to investigate or prosecute an extremely serious crime. So I'm going to get a little bit more into that, but I mean an extremely serious crime. It can't be a he said, she said, or civil action, or this one, or divorce, or some, something. It has to be an extremely serious crime that they're investigating. And then 3, disclosure is necessary in a proceeding in which the patient has already provided evidence about confidential communication. So, or the patient has already disclosed this information to the court, so it's not confidential anymore because the patient has disclosed it as part of their testimony or information. So I guess they waived the confidentiality there, and that they need additional information. Okay, and then there's other stipulations as far as what has to exist. For example, that there's no other reasonable way that they can get the information. But these things have to be decided in a reason to show cause that these situations exist. It's not just something that they willy-nilly issue a court order about. So if you receive a court order and it goes up to your program director and legal department, they want to know that these procedures were followed prior to the issuance of a court order. And here, just let me say that, yes, these trainings are for us as counselors, but also when I train people, I'm also training you to be a clinical supervisor, or you may be a clinical supervisor watching this online training course. And this is the information that we need to know as supervisors. That we just can't, bend and knuckle. Oh my God, I got a subpoena. I have to rush to court and divulge information. No, you don't. Okay, so I'm just reading here again. This is about subpoenas. If the subpoena is requesting records protected by federal confidentiality guidelines covering chemical dependency information, a subpoena will not be sufficient to force the releasing of the information. A court order based upon a hearing will have to be issued before records could be released. So if it's just a subpoena, it doesn't work, and they have to have a hearing, and the judge has to decide that a court order is issued and it's signed by a judge. So if you receive a subpoena, you already know what you can do with that. If you receive a court order, and this is important, that it be signed by a judge, okay, you don't want to ignore that. Okay? You don't want to ignore that. Whether it goes up to the legal department, it can't be ignored. And the reason you can't ignore that is because you could be found in contempt of court. And the judge can send some police officers to your house or to the program and pick you up and drive you, drive you to the court and bring you before him. He's going to ask you, why didn't you show up here? You ordered, and you could be held in contempt of court. As a matter of fact, he can have you taken downstairs and put in jail right then and there. So you don't want to ignore a court order. You receive a court order signed by a judge, you have to respond or show up. And you could, again, I'm not giving you legal advice here, but you could show up in court and say to the judge that I can't release that, I can't divulge that information. That's privileged information under Jaffe versus Redmond, and you could say, I'm not going to say it out loud here in court. You could request to go back into the judge's chambers and divulge the information in a confidential setting. If you're following the court order, get the attorneys to go back there, but you can also claim some privilege there. Also, if it's information that's going to be used in the defense of the patient, you don't have to divulge that information. That's privilege, and it's part of the defense, where you're going to give expert testimony as part of the defense. Then you don't have to give that information to the other side. There's not discovery there. That's works the other way, where the prosecution has to release the information. But If it's important information to the defense, then you don't have to release that, and that you're going to give it in court as part of the defense. Now, if the patient, or if you're going to be part of the defense, if the patient can give you permission to release that information, either way, and you're going to have a signed release of information specific to that information, and then that's okay. You can release that information in court because you have the patient release. Okay, all right. So I'm just going to cover something else here about search warrants. Okay, so search warrants, similarly, may not be used to allow law enforcement officers to enter a program or a program's facility. So if police come with a search warrant, we have a search warrant, okay, that doesn't give them permission to open, that they can go into the facility and search the facility, and definitely not search patient records, but they can't even search the program, because they're going to see the people that are there in treatment, and that's all confidential. So, however, arrest warrants do permit law enforcement personnel to search for a particular patient who has committed or has threatened a crime on the premises of the program or against program personnel. So if the patient has committed a crime on the premises of the program, or threatened to commit a crime or do harm to personnel of the program, the police can come in with a search warrant to seek out that patient and take him into custody. But unless the arrest warrant is accompanied by a court order, the program may not cooperate with search for a patient who has committed a crime elsewhere. So if a search warrant is not accompanied by a court order, the police can't come into the facility and search the facility for a patient and arrest a patient if the crime was committed elsewhere. Okay, if it's been committed on the premises, then they can come and take him out because he's committed a crime on the premises, and you probably don't want him there anyway. Okay, so let's have a look at my notes here. So I think I have a pretty clear idea of where we stand on with regard to subpoenas and where we stand with regard to court orders. So let's just have another look at the coercious patient's rights and responsibilities that we looked at in the other lesson. Okay, so let's have a look here. Patients have a right to, and I quote, receive confidential treatment, period. Okay, so patients have the right to receive confidential treatment, period. Except, whoa, look at this, except for a medical emergency, court order, child abuse, or crimes committed on the program's premises. Okay, so OASIS knows that. They're giving it to us right here. Okay? Confidentiality, except for medical emergencies, court orders, not subpoenas. It doesn't say subpoenas anywhere on this document. Okay, so just let me tell you a little bit about a medical emergency. So if there's a medical emergency, and I'll give you an example, real life example, patient passed out in my office as part of the counseling we were doing. And what he did was he actually overtook his medication, and it made him pass out. So he passed out in there, and we had to call an ambulance. When the paramedics came and they were trying to revive him, I told the paramedics what medication he was prescribed and what he was on. And as they were putting him on the gurney and putting the mask on him and pumping air into him and making sure he was breathing, I quick grabbed this chart and got a list of the medications he was on and gave the paramedic that information, and also gave him his name, date of birth, so that when he got to the hospital and the doctor that was treating him, they were trying to revive him, maybe even save his life. I mean, he was dying, but so that the paramedic could inform the emergency room doctor what medications he was on, and they were mental health medications, what his diagnosis was, what his name was, and what his date of birth was. That was a medical emergency. And of course, with regard to child abuse, we're all legally bound by, because we're mandated child abuse reporters. Okay, so that ends this lesson with regard to what do you do if you receive a court order? And I think you have a pretty clear idea of what you got to do about that now. Okay? Okay, let's move on.